Hi, today we will be discussing the origin and development of the legal profession in India. This topic is very important if we talk about the professional ethics in Indian legal system. So, let us start. We can divide the development of legal profession into four different timelines: the ancient Indian period, the medieval Indian period, the British period, and the independent India. During the ancient Indian period, the base for justice was dharma and the king was the judge. Parties in dispute directly approach the king or others who are deputed by the kings to manage justice at local level. There were no legal personalities like vakils or advocates at that time. During the medieval Indian period, when Mughals conquered India, they brought two levels of courts, that is Zilla Court and Sadar-e-Diwan, and also the concept of vakils or advocates. The Mughals introduced a system where government advocates work free of cost for the poor people. During the British period, the first court was established in the year 1672 in Bombay. Governor Aungier introduced the famous Charter of 1726, which created the Mayor's Court in Bombay, Madras and Calcutta. There was an amendment in the charter in the year 1753 to remove the entire localness from the original act. The Charter of 1774 removed all the Mayor's Court and created the Supreme Court of Calcutta in the year 1774, Supreme Court of Madras in the year 1801, and then Supreme Court of Bombay in the year 1823. In independent India, the All India Bar Committee was constituted in the year 1951. After that, the Indian Advocate Act 1961, which is still prevailing in the legal profession, came into existence. And then we also got the Contempt of Court Act 1971. Before the Charter of 1726, the Indians were not allowed to practice in the court of law. The Charter of 1726 brought a lot of recognition, wealth and prestige to legal profession. With this charter, the courts got the power to approve, admit and enroll advocates and attorneys to practice, and also prohibit practitioners from admitting and enrolling as advocates. The court had the power to dismiss both the attorneys and barristers, and admission was done with great influence from England. The Legal Practitioners Act brought all the different forms of legal practitioners into one single umbrella and termed them as an advocate. And in the year 1940, India got the system of legal education. Now let's see a few important timelines of the British period. The period starts from the year 1726, when the Charter of 1726 introduced the Mayor's Courts in 3 cities of India. Then there was an amendment in the year 1753, but the important amendment came in the year 1774, which made the Mayor's Court a Supreme Court. And after that came the Indian High Courts Act 1861. The important act is Legal Practitioners Act 1846, which was amended in the year 1853, 1863 and 1879. And then comes to the very important All India Bar Council Act in the year 1926. Bar Council with 15 members under each High Court were being established, and High Courts were preparing the role of advocate. In the independent India, there are two important aspects. One, the All India Bar Committee in 1951, and the other one, Indian Advocate Act 1961. Now few key information from the All India Bar Committee, which was led by the chairmanship of Justice S.R. Das. This committee brought uniformity in the legal system of India. Then this also brought one term for the practicing legal professionals, that is the advocate. Now one bar council at the national level, and then one each bar council at each state level was formed. Each state has to maintain and send a consolidated list of existing advocates, and also vakils and pleaders who had no legal graduation, but are still practicing at district or subordinate court, to All India Bar Council on the annual basis. Nowadays everything is online, so no waiting. There are certain essentials for a person to be an advocate. The person should be a citizen of India, minimum age should be 21 years and is a law graduation. Now, if you are a practicing advocate in India, you can practice in any court of India, lowest of the lowest courts. And up to the level of the Supreme Court, you can practice anywhere in any courts of India. The Indian Advocate Act came in the year 1961. This has 7 chapters and 60 sections. Chapter 1 deals with preliminary aspects, which is short title extent. Chapter 2 deals with bar councils, covering from section 3 to section 15. Chapter 3 deals with admission and enrollment of advocates, covering from section 16 to section 28. Chapter 4 deals with right to practice from section 29 to 34. Chapter 5 deals with conduct of advocates, covering from section 35 to 44. Chapter 6 deals with miscellaneous provisions coding from Section 45 to 52. And Chapter 7 deals with temporary and transitional provisions from Section 53 to 60. It also explains the functions of the Bar Council of India, especially in Chapter 2, which are the general supervision of State Council, maintaining the role of advocates, controlling disciplinary procedures, which must be followed by the disciplinary committees of the State Council. Then protecting the rights, interests and privileges of the advocates, supporting the law reforms and promoting standard legal education through universities. That is it for now. Best of luck and have a great learning time.